So the next speaker is Samantha Zyontz, and she is a research fellow of intellectual property and fellow at the Center for Law and the Biosciences at Stanford Law School. For the 2022 to 2023 academic year, she will be a visiting assistant professor at Boston University Law. Her research focuses on intellectual property strategy and the influence of institutions on breakthrough innovation, with an emphasis on the diffusion of CRISPR DNA editing tools. She received her PhD from the MIT Sloan School of Management. So thank you, Sam. Thank you, Tanya. I am thrilled to be here. Ooh, pretty slides. Hello, and again, thank you all for having me and inviting me. I've been having a great time in Iowa, so thank you. Today I'm going to talk really quickly about a bunch of work I've been doing for years, specifically looking at who actually goes on to build on innovations where we're unclear about who owns them. And specifically what I'm going to talk about today is the CRISPR-Cas9 DNA editing system, which currently is under dispute as to who owns the technology and what we're going to do about innovation and whether or not it was curtailed in any way. So really quickly, I'm going to do CRISPR in 30 seconds. So CRISPR is the brand new DNA editing tool that won the Nobel in 2020. And it is an easier, cheaper, faster, and more accurate way of editing the DNA of pretty much any organism so far than any other tool we've really ever had. And for this particular talk, the only thing you need to really understand is that CRISPR-Cas9, which is the original version of this, basically consists of a small piece of DNA, which is represented by the yellow piece here in my figure, attached to an enzyme, which in this case is called Cas9. What happens is the little yellow piece of single-strand DNA is programmed to search for a very particular gene somewhere in a target DNA. So all you do is you take the little, you program the little DNA strand, you attach the enzyme to the back of it, you package it up, you shove it into the cell, nucleus of the cell, and it will go find that particular area. And what you're seeing here is the enzyme Cas9 wrapping around a very particular gene that the tool was asked to find. And what we'll do is we'll just cut it out in double-stranded break, which is gone. So, and all you need to care about here is that the patent that covers this particular invention basically consists of this DNA strand and the enzyme Cas9 very specific. Now, you think this would be simple, but it's not. What happened is that CRISPR is actually simultaneous, or modifiable CRISPR, I'll be more specific, is actually a simultaneous invention between folks at Berkeley and folks at MIT. And due to a artifact of the patent system, we're arguing over who actually invented it first. And so there have been a couple of cases that have gone on at the patent office. The first one literally asked, hey, if UC invented CRISPR first, is Broad and MIT's version of CRISPR, which only focuses on mammalian, not sort of a general purpose use, is that obvious in light of the fact that UC came first? And the patent office and the Federal Circuit said, no, they weren't. And so effectively, MIT got their patent and Broad got theirs. We split the baby. Or sorry, Berkeley got theirs. We split the baby. The patent office came back and said, oh, actually, maybe we were wrong about mammalian CRISPR. And just as did the UC actually invent mammalian CRISPR before MIT did? And this decision came out like 2 months ago. And they said, no, they didn't. So now MIT has rights to mammalian CRISPR, and UC has rights to general proof of concept and in a bacteria. And there are a few others that are going on. But basically, this has been going on since CRISPR was invented or introduced in 2012, which means the entire underscoring of this has affected how the CRISPR innovation ecosystem has started to work. And so from here on out, I'm just going to show you lots of pictures because it's really kind of cool to figure out, okay, what's going on? First of all, despite the fact that nobody knows who owned what, there's still an awful lot of innovation out there. So what you're looking at here is my co-author, who is a wonderful RA of mine at Stanford, actually looked at and collected every CRISPR patent family that was published with the earliest priority date of December 2018. And what you'll see is, in 2012, in that early time period, there's almost nothing. By 2018, we have an exponential increase in the number of people patenting. So our question was, who's doing this? And the first answer is, well, it's folks in the US and China. And more specific, the folks in China, had a slow ramp up period, but all of a sudden completely, started to outstrip the US in the number of patent applications that is put in on CRISPR. And some of this is actually because of the 5-year plan in 2016 that the Chinese government put out, said, hey, we need you to put in more patents and more papers on genetic engineering. And so that's what happened. And further, we were asking, okay, where is this going? And so we actually categorized all of these patent families, and we find out that the vast majority of them were like technical improvements to the tool itself, which made sense in the early period because we weren't doing much with it other than trying to figure out how the tool works. And so these are sort of incremental patents. But you'll also see that over time, health and medicine applications became very, very prominent. And again, agriculture and livestock, which is really going to become very, very important going down the line. And also what you'll see, we found, is that different countries actually dominated different areas. So the Chinese patents are, the predominant players in the agricultural space, whereas in health and medicine, it's the USA. And that actually kind of makes sense given where CRISPR started in the US versus what China was focusing on in its 5-year plan. The other thing that we've noticed is that, the top applicants actually have licenses to Cas9, but not everybody does. And more specifically, not everybody's got licenses to both the Broad application or the applications and the UC applications. So some people have only licenses to one portfolio and some people only have licenses to the other. That's interesting. But what really started to happen is people got tired of listening to the fighting over Cas9 and instead went out and found a whole bunch of other enzymes that is still CRISPR, still usable, but does not interfere with the patents that are at issue in the interference cases, because that's not what patents come. So instead, what we see is as soon as these new enzymes became available, they started entering into all the new patents. And so this is what happens in the claims, where you get Cas9 only versus combinations of Cas9 and any other Cas that came out. There are a few that are not specified that we're still looking into. But this is real wonderful evidence of actual design around, which I'd love to see. It's really hard. But to kind of just finish here, to just say, mutually exclusively, who is building on CRISPR despite all of this? About 14.6% of the applications are these new enzyme combinations. So they don't interfere with these Cas9 patents at all. 50% of them are outside the US. These are all the Chinese patents made by Chinese people for China. 22% or almost 23% are research applicants. So they're universities, even if they're just using Cas9s, they're unlikely to get sued at all. And then 5.3 are corporate applicants who have a license. And then the remaining 8 are those that we're not so sure about and may need a license. So I'll stop there, but thank you again for your time.